the three of you for being here today and for your willingness to serve. Mr. Eisenberg, I'd like to start with you, if I could. During her confirmation hearing, Attorney General Bondi and I had a conversation about FISA Section 702 and about the use of what I sometimes refer to, for lack of a better word, as de facto warrantless backdoor searches, meaning searches of U.S. persons through a U.S. person identifier known to be a U.S. person identifier, to search the databases containing incidentally collected content communications involving U.S. persons, U.S. citizens, and others here in the United States, lawful permanent residents and so forth. And I asked Attorney General Bondi specifically whether she would agree with me that these de facto warrantless backdoor searches are concerning in that context. She responded in the affirmative with the word yes. That leads me to my question. Would you agree that these backdoor searches of incidentally collected communications involving American citizens are concerning?
Thanks for the question, Senator Lee. I certainly agree that it does raise issues that if you search a database, substantially large database. I don't at this point, however, know what protections are in place since I'm not currently in NSD. So if I were confirmed, I would talk to the experts in the NSD about exactly what they do, and I would then talk to the Attorney General and help come up with perhaps different procedures if those are warranted.
I appreciate that, and I would add here that for the entirety of the 14 years that I've been a United States Senator, the whole time I've served on this committee, I and others, including people on both sides of the aisle, including Senator Durbin over the years, we've raised concerns with this. On each occasion, we've had officials from the FBI tell us, don't worry, we've got procedures in place. You don't need to worry about additional legislation. We've got it covered. And in each instance, when they come back, they usually tell us, okay, yeah, we discovered there have been some abuses, but now we've really got it covered. The bottom line is I do believe Congress needs to act here. I think we need additional protections because those internal protections haven't worked. Because we're trying to ram a giant square peg into a round hole. It doesn't work. In my view, it is not compatible with the letter or the spirit of the Fourth Amendment to allow those sorts of things. Now, Mr. Eisenberg, you've spent much of your career in national security law. With that, you've got vast experience with the FISA court and the FISA Court of Review. What reforms, if any, do you think perhaps ought to be made to the FISA court or the FISA process?
Thanks for the question, Senator. I think this is something that I need to study as soon as I get into NSD, if in fact I'm confirmed. In my view, it has to be possible to do better in order to at least assure the American people that the sorts of privacy protections that are in place are actually working. But as to the actual details, I think I need to get in there first if I'm confirmed.
Gotcha. Mr. Shoemate, let's turn to you. For a long time, I've been troubled with Congress's chronic delegation of the lawmaking power. As you know, Article 1, Section 1 makes Congress the sole sovereign lawmaking authority within the federal government. Article 1, Section 7 makes that doubly clear by saying you cannot make a federal law without both houses of Congress passing the same legislation, bicameral passage, followed by presentment to the president for signature, veto, or acquiescence. Congress has deviated from that, and the courts have been unwilling to enforce that part of Article 1, Section 7 for reasons that escape me, while acknowledging that the non-delegation principle exists. They just refuse to enforce it. Now, in your Senate Judiciary questionnaire, you listed a case that you worked on called All-State Refractory Contractors versus Sue. And in that case, you challenged the constitutionality of the OSHA statute. What can you tell us about your involvement in that case and what your involvement in that case sort of taught you or what you gleaned from that as far as Congress's ability to delegate its lawmaking power?
Thank you for the question, Senator. Yes, so that case reinforced for me the importance of Article 1, the vesting of legislative power in the Congress. And in that case, we were representing a client, All States, which is a general contractor in Toledo, Ohio, that was challenging OSHA's statute, which under the non-delegation doctrine, which is a longstanding doctrine in Supreme Court precedent that says that Congress can't delegate its legislative power to the executive branch. And under the OSHA statute, Congress has allowed OSHA to promulgate numerous safety regulations that impacted my client. And so in that case, we were challenging the statute on its face as a violation of the non-delegation doctrine. We thought we had pretty good arguments. We went up to the Sixth Circuit. The Sixth Circuit upheld the statute in a 2-1 decision, and the Supreme Court denied cert in that case. So reinforced for me, Senator, the importance of the structural separation of powers and that each branch stay within their proper role.
Indeed. I see my time's expired, and I'll note as you say that this is not merely a hypothetical problem. 100,000 pages of new regulatory text issued last year. By some estimates, those 100,000 pages of new regulatory text put in place entirely by unelected, unaccountable bureaucrats cost the American economy $1.5 trillion annually. Think about that. That's a problem. Thank you, Mr. Chairman.
Senator Ronald.
Thank you, Mr. Chairman.